Straight ahead on Law&Crime Daily, a former teacher of the Parkland school shooter testifies for the defense.
I strongly feel that Nicholas is a danger to the students and faculty at the school. I do not feel that he understands the difference between his violent video games and reality.
Plus, the Kobe Bryant crash scene photos. Will Vanessa Bryant move forward with claims against Los Angeles County at the state level? And the defense calls its first witness in the federal sex crimes trial of R&B singer R. Kelly in Chicago. But first, the jury views crime scene locations in the trial of Pike County Massacre defendant George Wagner IV. Law&Crime Daily, covering court cases from coast to coast. Okay, welcome everybody to the Law&Crime Daily. I am your host, Imran Ansari, in for Brian Buckmeyer. Ahead of opening statements in the trial of George Wagner IV, jurors visit crime scenes of the Pike County Massacre. Correspondent Anjanette Levy joins us from Ohio with a location breakdown.
For a second day in a row, jurors in George Wagner IV's murder trial were taken to locations that are important to the investigation into the murders of 8 members of the Roden and Gilley families.
The 12 jurors and 6 alternates rode a school bus to Union Hill Road for a jury view. They saw the 3 properties where 7 members of the Roden and Gilley families were shot to death in the early morning hours of April 22, 2016. Many of the family members were sleeping when they were shot in the head. Children in the homes were left unharmed. The trailers have since been placed in storage to preserve the crime scenes. But on Chris Roden Sr.'s property, you can see a faded poster asking for clues about who killed him and his family.
This is a little bit like the Hatfields and the McCoys. This is a little bit like one family being very angry at another family.
Mark Weaver is a former deputy attorney general for the state of Ohio. Weaver says prosecutors allege the Wagner family is part of a criminal enterprise and that they were part of a conspiracy to kill the Rodens and Hannah Gilley. So Jake Wagner and his family could have full custody of the daughter Jake shared with Hannah Mae Roden. The Wagners are accused of killing anyone who could have tried to take custody of the little girl. Jake and Angela Wagner have already pleaded guilty and agreed to testify against George and Billy Wagner. Jurors also visited the home where the Wagners lived at the time of the murders. It's where prosecutors say shell casings were found that had the same markings as those found at the crime scenes. They also said they found charred pieces of the Rodens' surveillance camera system stolen by the Wagners that night to cover their tracks.
You're talking about a group of people, a family group, that sat around a kitchen table, perhaps, or in the front room or on the front porch. And allegedly, they planned the slaughter of another family.
And these visits to the 4 crime scenes and other locations attached to the Wagner family are very important for the jurors as they prepare to hear opening statements next Tuesday. For Law&Crime Daily, I'm Anjanette Levy.
Okay, joining us today is my co-host, Terry Austin, and criminal defense attorney Matt Mangino. Matt, I want to start with you. How common is it that juries are allowed to view the scene of a crime, and what are the criteria for the judge in allowing such a viewing?
Well, the criteria, first of all, is that visiting the crime scene will provide some meaningful opportunity for jurors to get a better context, a better understanding of what happened, particularly in this situation where there's 4 separate crime scenes. You know, what's interesting is we saw in the Cruz case the unprecedented situation where you go into a crime scene that is pristine, that has been kept exactly as it was on the day of that terrible massacre. And we saw recently in the Matthew Moore case, the staged suicide, where they went out to the crime scene, I believe, before any testimony was presented, which is unusual in itself. But here, clearly, this was an appropriate opportunity for the jurors to get a chance to see the various crime scenes.
And Terry, the jury is viewing 4 different scenes together. In fact, they even rode the bus together. How difficult is it not to discuss what they saw?
Well, you know, they are instructed not to discuss the case before all of the evidence is in. And when they go out to that crime scene, they are actually looking at what exactly happened and where it happened. Matt raised some really good points that this evidence is being kept as it was. Now, this might not be pristine because it's outdoors and all of that, but I think that most of the viewings where it happened inside and the gunshots took place is probably the way it was when it happened at the time. I would think that those jurors would be affected. They'd want to talk about it. They're getting specific impressions and they have emotions and they might say to each other, look, can you see? Isn't that amazing? It happened right here. Now, I suppose that talking about it in that way wouldn't be any sort of misconduct, but I am certain that they are trying very hard not to talk about the case.
Okay, thank you, Matt and Terry. And headed south to Georgia, where a 14-year-old girl is arrested for setting fire to an Atlanta area Walmart. It happened on August 24th at a Walmart in Peachtree City, Georgia, about 40 minutes south of Atlanta. Photos showed the charred aftermath of what was once the store's grocery area. It took about 9 hours for emergency responders to put out the flames that caused extensive damage to the building. 3 responding officers were hospitalized with smoke inhalation, but they have since been released. Officials say the 14-year-old girl responsible for the fire has since been arrested and charged with first-degree arson. Her name has not been released as she is a minor. And still ahead on Law and Crime Daily, fresh off the heels of her win against Los Angeles County, Vanessa Bryant could soon be headed back to court. But first, R. Kelly's defense team calls their first witness as the singer stands trial for federal sex crimes. Welcome back. A federal judge denies R. Kelly's motion for acquittal as the singer indicates he will not testify in the trial. The 55-year-old convicted sex offender now stands trial in Illinois on federal sex crimes charges. Back in 2008, the singer was acquitted of charges for creating a video of himself having sex with a 14-year-old. At the time, the alleged victim and her family denied their involvement. But 16 years later, the accuser and her mother testified for the prosecution, saying they lied about their involvement after Kelly threatened them. The defense began its case on Thursday, where Kelly indicated he would not be testifying. The first witness called was a former Chicago police officer. Kelly is being tried alongside 2 co-defendants who prosecutors say kept the singer's crimes under wraps. Okay, Terry, co-defendant Daryl McDavid is charged with child pornography and also helping Kelly rig the 2008 trial. He said he will testify. What do you think we can hear from this defendant?
Well, first of all, I think it's a mistake to testify. I mean, he could unintentionally open some doors in other areas. And of course, he's going to be subject to cross-examination, and that's going to be very difficult. But look, he's the longtime business manager for Kelly. He knows Kelly. He knows the operation. He's going to get up on that stand, and I think the jury is going to pay close attention to what he has to say. I think he's going to be very defensive about what he did, about what Kelly did. And what he's going to say is it was his job to protect Kelly and that he wasn't in any way, shape, or form involved with pornography and definitely not involved with making a rigged 2008 case and with trying to get witnesses not to testify. That was a big part of what was going on in 2008. Some of those witnesses got phone calls from the business manager and others allegedly and were really frightened and did not testify, including the victim and her mother. So we'll see what happens, but I think he's going to be very defensive on that stand, and he better be careful when it comes up to cross-examination.
Okay, and Matt, co-defendant Milton Brown is charged with receiving child pornography like Kelly, and he said he wouldn't testify like Kelly. Was that the right move?
Well, you can't be compelled to testify as a defendant. You have the right to choose not to, and the jury can't really consider that against you in terms of their deliberations. But, human nature tells us that jurors want to know the defendant's version of the case. They want to hear from the defendant. They want to hear why they've been accused, why they're not responsible for the actions that they've been accused of. So Well, they have no responsibility. Jurors want to know what they have to say.
All right, thank you, Matt and Terry. And switching now to Idaho. As attorneys for Lori Vallow Daybell, half of the so-called Doomsday Cult duo, are seeking to ban cameras from upcoming court hearings, claiming the media have abused their privileges of filming and taking photographs in court. Prosecutors believe Lori conspired with her brother Alex and husband Chad Daybell to murder her children, JJ and Tylee Ryan, for Social Security money and as part of a religious pact. They're also charged in the death of Chad's former wife, Tammy. The children's remains were found in June of 2020, months after they went missing, buried on Chad's property. In a motion filed this week, Lori's defense attorneys referenced a hearing 2 weeks ago, which was broadcast and recorded with the judge's permission. They claim the cameras set up in that hearing zoomed in on Vallow and could have violated attorney-client privileges. The attorneys are requesting that cameras be banned or that only still photography is allowed moving forward in the case. Vallow and Daybell both face the death penalty. Their trial is set to begin in January of 2023. And coming up on the Law&Crime Daily, the defense continues its case in the Parkland school shooter penalty phase trial. Plus, fresh off a win against Los Angeles County, Vanessa Bryant could pursue more legal action. Why the release of the Kobe Bryant crash photos could call for invasion of privacy claims. Welcome back. Vanessa Bryant's lawsuit trial against Los Angeles County may have come to a verdict last week, but the case isn't quite over. Bryant, along with financial advisor Chris Chester, sued Los Angeles County after photos were taken of the remains of their family members, including NBA great Kobe Bryant, their daughter Gianna, and Chester's wife and daughter, following a fatal helicopter crash back in 2020. They filed the suit claiming first responders took photos at the crash site and shared them with others through text messages and in public. After several weeks of testimony, a jury awarded Bryant $16 million and Chester $15 million by following the verdict forms. But that was later adjusted to $15 million each after it was discovered there was a clerical error. Bryant still has another potential case awaiting her in state court, as she can now move forward with the California invasion of privacy claims, which were separated from the federal civil rights claims before trial. Bryant has until September 19th to decide whether she'll pursue those claims related to the actual taking of the photos, whereas the federal claims had to do with their distribution. Matt, the state case has to do with the actual taking of the photos, while the federal case had to do with their distribution. Do you think this case in state court will be easier to defend than the one in federal court?
Well, the issue is going to be invasion of privacy, which is separate from the civil rights action that was filed. We know based on testimony in the federal case that there were at least 8 firefighters or other emergency personnel from Los Angeles County that had taken photographs. And what Bryant has to prove in this state case is that taking those photographs was an invasion of privacy for her family, that her loved ones who were killed in this accident, their bodies were on display, and that was an invasion of her privacy, and that she was harmed by that she was damaged by that, and she's entitled to compensation for it.
Yeah, Terry, this is an interesting situation given the recent verdict. Do you think that Vanessa Bryant will pursue these state claims?
You know what, Imran, I think she might actually pursue these state claims. They were part of that federal case, and they were separated, and they were brought for a specific reason. Even though they were separated, I am certain that she still probably wants restitution for the invasion of her privacy there. And so she's going to make sure that all of those defendants are held accountable for all of those actions, not just distributing the photos, but actually taking unnecessary photos. If they were supposed to take photos of all of those bodies, well, then that's one thing. But I think it could be deemed an invasion of privacy if they weren't supposed to take it. Some people might think that state case is a waste of time. It's a waste of taxpayer dollars. She's already had her day in court. But I do think she is setting the way for others and making sure that those police officers and first responders and firefighters follow policy and don't do this again. She has every right, I think, to bring any claim that she has in the state court as well.
Thank you, Terry and Matt. Will be keeping tabs on that case. And despite being denied 11 times, the man convicted of killing English musician John Lennon is up for parole again. Mark David Chapman was sentenced to 20 years to life in prison after pleading guilty to shooting John Lennon 4 times in front of his wife, Yoko Ono, as he was walking into his luxury New York apartment in December of 1980. Chapman was an out-of-work security guard from Hawaii who had a history of mental illness. He was first eligible for parole 22 years ago, and he's been denied 11 times since. At the latest parole hearing and subsequent denial in August of 2020, Chapman told the parole board, quote, "I assassinated him because he was very, very famous, and that's the only reason. I was seeking self-glory, very selfish." He was set to appear for a parole hearing in upstate New York sometime this week. And when we come back, life in prison or the death penalty, a Florida jury must now decide the fate of Parkland school shooter Nick Cruz. Welcome back. A defense motion for mistrial is denied on day 20 of the Parkland school shooter penalty phase trial. In February 2018, a then 19-year-old gunman opened fire at Marjorie Stoneman Douglas High School, killing 17 people and injuring 17 others. Last year, the gunman pleaded guilty to all counts. A Florida jury will now decide whether he receives life in prison or the death penalty. On Thursday, defense attorneys motioned for a mistrial, arguing their client's constitutional rights were violated when an earlier evidentiary motion on the introduction of a swastika was not decided. Judge Elizabeth Scherer denied the motion. The defense then called Carrie Yon to the stand, who worked as the defendant's middle school teacher. Yon read excerpts from her notes to the jury.
I strongly feel that Nicholas is a danger to the students and faculty at the school. I do not feel that he understands the difference between his violent video games and reality. He's constantly showing aggressive behavior and poor judgment. His drawings in class show violent acts, people shooting at each other, or creepy sexual pictures, dogs with large penises. He's pretended to masturbate in class. He uses foul language and disregards everyone around him. Nicholas has been reprimanded on many occasions, verbally, referrals, IS, etc., and continues to act in the same manner over and over again. Showed Linda Nick's work and explained the seriousness of it. She did not seem very concerned. She claimed that he's a boy going through puberty. We also discussed his obsession with guns and violence. She stated that he's interested in buying a BB gun from Walmart and was asking his mom repeatedly if he could get the gun, promising that he would just shoot at trees.
Okay, let's bring in Matt and Terry. Matt, I'll start with you. The judge got pretty upset today, mostly with defense counsel. How do you think she is managing her courtroom thus far?
Well, I mean, this has been a long trial, and it's going to continue to go on. I mean, I think she has managed the courtroom as well as you would expect a judge to do. I mean, she's granted some leeway when it was appropriate, but there's a lot of issues here, and the one issue that came up today with regard to a what may be some undue influence by the prosecution on one of the witnesses is certainly an issue that I don't think is going to go away. I think the record has to be established on exactly what that conversation was about. So there are a lot of issues, separate from actually the testimony that's been coming out here from the defense. And I think what the defense is trying to do is say, hey, the system failed Nicholas Cruz. The school district failed Nicholas Cruz, and try to create some sympathy among these jurors for that premise.
And Terry, the defendant's former teacher mentioned a lot of disturbing behavior in his middle school years, saying the school wasn't equipped for his needs. Should these actions have been a warning sign of things to come?
Oh, most definitely they should have been a warning sign. The actions that he did while he was in middle school were really far worse than anyone else had ever done. And they testified as much, that she basically said she hadn't seen anything quite like this before. I mean, not only did he have scribble and notes and drawings that were inappropriate and offensive, but his behavior was violent as far as she was concerned. And she tried to downplay it a little bit, but it basically was acting out against her, acting out against other students. She, in fact, was afraid. She had the assistant principal come in and sit with her because she was afraid. And even though they don't want to call it bullying, it was bullying, because if you verbally try to make someone fear you, that could be deemed bullying. And so I definitely think they saw this behavior, and it was behavior that should have been a clue that something else might come ahead.
Thank you, Matt and Terry, and thank you for joining us here on Law and Crime. We'll see you next time as we discuss justice in America.